Start para. In the instant writ petition filed under Article 226 of the Constitution of India, the petitioner challenges the impugned judgment and order passed by respondent number 1, which dismissed the petitioner's application for the conferment of deemed conveyance under Section 11 of the Maharashtra Ownership Flats Act, 1963 (MOFA Act), full stop. The petitioner principally relies on three grounds for its challenge. Firstly, that the developer has not yet availed the full floor space index (FSI) available for the development. Secondly, that as per the terms of the agreement governing the transaction, the right to conveyance is conditioned upon the complete redevelopment of all constituent societies, and thirdly, that the architect's certificate tendered in support of the proposal is erroneous, full stop. These contentions, if sustained, would undermine the validity of the impugned decision and the consequent rejection of the petitioner's plea for deemed conveyance, full stop para. The petitioner, having instituted the proceedings, submitted a proposal on 8th March 2022 before respondent number 1, seeking the issuance of deemed conveyance in accordance with Section 11 of the MOFA Act, full stop. It was contended that, pursuant to the sanction plan, the petitioner society possesses a built-up area aggregating to 9,140.83 square meters, computed as 8,923.86 square meters plus an additional 216.97 square meters within a total built-up area of 17,676.95 square meters, full stop. Accordingly, the petitioner society purportedly hold a 51.71% share in the larger plot, a quantum certified by a registered architect, full stop. In light of this entitlement, the petitioner prayed for the issuance of a certificate of entitlement for unilateral conveyance of land admeasuring 4,199.93 square meters out of a larger plot of 8,122.1 square meters, situated in the land bearing CTS number 54/C, village Kandivali, Devnagar, Mumbai, full stop. In addition, the petitioner sought an undivided share in the common recreation ground, specifically, 741.16 square meters out of an overall area of 1,433.29 square meters, as well as an FSI benefit for the setback area, quantified as 2011.51 square meters out of 3,889.94 square meters, inclusive of the existing building, full stop. These precise calculations and measurements were tendered to substantiate the petitioner's claim and to delineate the exact quantum of its entitlement under the redevelopment scheme, full stop para. In response, respondent numbers 2 and 3 vehemently opposed the application on multiple grounds, full stop. They averred that, by virtue of the agreement to sell entered into by the members of the petitioner society, it was unequivocally stipulated that the conveyance of the disputed land was to be effected in favor of a federation comprising both the extant societies and those to be subsequently constituted. Stop.